All right, hello everyone. Now, I guess I am the one, in fact, who's standing between you and the reception, but I'm going to take my time, only the time that I'm allotted, of course, because I'm very excited to speak to you. I'm Chiraag Bains. I work at the Civil Rights Division for the U.S. Department of Justice, and I want to talk to you today about some of the work that we're doing on criminal justice reform. So, we are in this very special moment where there's a lot of energy, more energy than there's been in a couple of decades, I would say, around criminal justice reform. And it's partly a result of tragedy, it's partly a result of mobilization, people in the streets, people mobilizing in other ways. It's partly the long-term product of efforts of advocates, including many of you in this room. But we are having a debate about criminal justice reform, and it's a moment of opportunity. And so I'm extremely excited to be here with you today because bail reform has to be a part of this conversation. And for us, the reason, or one of the main reasons, is that bail reform or the practices of bail are a major driver of mass incarceration. Okay? So let's think about that for just a moment. One way in which they're a major mass incarceration driver is that the population of pretrial detainees in our local jails is increasing at a rate that is far above the population of people who are convicted and serving time in our jails. There's a report out just yesterday from the Prison Policy Institute that shows that the rate at which people who are convicted are serving time in local facilities has been flat for the last 15 years. And roughly 2/3 of that number, people serving in local jails, which is about 700,000 people, give or take a bit, is people who are actually innocent. These are people who are rather legally innocent, so they're pending trial. They have not had their day in court yet. So that's one reason that this should concern us. Another reason, probably even more troubling, is that the research shows us that there are follow-on consequences from being detained pre-trial. So if you are detained pre-trial, you are more likely to plead guilty. You are more likely to be convicted overall. You are more likely to be sentenced to time in jail or in prison, and you are more likely to get a longer sentence. So with that backdrop, I want to focus in on DOJ's efforts. We've been increasingly attuned to this issue of bail reform, and particularly the issue of money bail, cash bail. Pretrial detention is necessary sometimes to protect the safety of the community and to deal with flight risks. I take that as a given. That is not something I'm here to debate. But I do think, and we think, that in many cases, bail practices around the country penalize people for their poverty. And so consider the story of a woman named Christy Dawn Varden. Christy was a resident of Clanton, Alabama. She was a 41-year-old woman. She had 2 children, and she was arrested in a Walmart for shoplifting, and she had some other misdemeanor charges. It was 4 charges in total. And the way that Clanton ran their bail system was that you had to pay $500 bail per misdemeanor charge that you had. So she had 4 charges, $500 apiece, $2,000 to get out of jail. She didn't have $4,000. She said, in her own words, she said, "I'm indigent, I have no assets, I have no bank account, and no real property. My only source of income is food stamps. I cannot afford to buy my release from jail." But the way that Clanton worked, again, was that they had this bail schedule, and if you couldn't post the bond, you had to sit in jail. And so that's what she did. She sat in jail, and while in jail, she filed suit against the city, claiming that this was essentially an illegal bond scheme or bail scheme. And the Department of Justice, the Civil Rights Division, filed a brief supporting her claim. And this, I guess, is the big idea that I'm contributing here, which is that there are constitutional principles with real application to this set of issues, and litigation is one way in which we can affect change. And I think we can't litigate everywhere, but put it on people's radar so that they understand that there's a constitutional valence to this set of problems. It's not merely that we're choosing policy here. So we said in that brief that it's the position of the United States, that is the federal government, that any system that sets bail based on fixed amounts per offense, without any individualized assessment of a person's circumstances, without any consideration of that person's finances or financial circumstances, violates the Equal Protection Clause of the 14th Amendment. And the principle is actually broader than that. If you read the brief, it's not limited to bail schedules where there's sort of, in fact, a form that tells you which offense corresponds to what amount of a bail. The principle is indeed broader. A system of pretrial release that works differently for the wealthy and for the poor offends the bedrock principle of equal justice under law. In that case, our court filing had an impact. The city of Clanton announced changes very quickly thereafter, releasing most defendants without requiring them to pay any sort of bail. So that's one example, but just one example. I'll give you one other, which is the city of Ferguson, Missouri. I work on the Ferguson, Missouri case where we investigated and later filed suit against the city for its police and court practices. So to focus in on the court practices and the detention practices, among the many problems we found was that when people were arrested, they would be held on bail set by the jailer, sometimes in consultation with the court clerk. And in their case, the court is a part of the police station, in fact. So you walk from the jail up the steps to the court. And what they would do is they would hold people on bond, on bail, that they had set based on something like a schedule, and hope that they could make the payment, because they didn't conduct any kind of inquiry into the person's financial situation. So the person might say, I don't have any money, and they would say, well, make a call. And the way the jail was set up, there were phones in the jail cells. So there wasn't much in the jail cell, but there was a phone, and you could use that to call friends, family, and so forth to try to come up with the money. And they would hold folks until they either made the payment or it just became clear that they were not going to come up with the money. And what we saw is that they would drop the bail as time went on. You know, the next day they'd cut the bail in half. We'll say, okay, could you make $500? And could you make $200? And then ultimately just release the person, which shows you that the system at work there was not based on public safety. It wasn't based on flight risk. It was based on collecting revenue, which was a particular problem in Ferguson. I think it exists everywhere. And it may not be the case here in New York City, but it's a pretty prevalent issue we've found. And so we ended up suing Ferguson, and we settled with them last month, and we now have a consent decree. And in the consent decree, we've eliminated the use of secured money bond in Ferguson. So the city will no longer use a bail schedule. It's an important development. It will no longer use a bail schedule, but it also will no longer require the posting of upfront money, cash at all. With very narrow exceptions related to dangerousness, everyone has to be released on ROR or unsecured bond, that is a promise to pay a certain amount if you don't show up, and that bond cannot exceed $200. These are all very low-level offenses, so the remedy here is correlated to the fact that these are mostly infractions. These are lower than misdemeanors. So that's a little bit about some of our casework. In the briefs that we've filed on this issue, we've talked about the legal arguments, but we've also said we, the United States, think that it constitutes poor public policy to rely exclusively on money bail or to over-rely on money bail. And you've heard some of the reasons throughout today. You heard a couple of times citations about public safety, research showing that the use of money bail and pretrial detention on money bail is correlated with recidivism. The fact that it's expensive, you have to hold these folks in jails, which it ranges, but sometimes $50 to $150 a day in county jails around the country. And DOJ has estimated that it's some $9 billion are spent on pretrial detention around the country every year. We've heard about how it destabilizes people's lives and their communities as they have problems with housing, work, relationships. And we didn't hear as much about this, but there are also racially disparate outcomes. Just to give one example, African Americans and Latinos are at least twice as likely as whites to be detained pre-trial for nonviolent drug offenses. But there's one other thing that I want to focus in on, one other policy reason why we should care about this. And it's that this kind of bail practice, that is the reliance on money bail to detain people without regard to their ability to pay and without regard to their financial circumstances, erodes trust in government. So we have more than a generation of research on procedural justice. That is, the idea that how you're treated by law enforcement and by other forms of your government, how you experience that system has a significant impact on your willingness to obey the law and the way in which you view the legitimacy of those institutions. And I would say this idea applies equally to pretrial detention, where people's liberty depends on their wealth. They'll be more likely to see the system as rigged, and the system being their government as a whole, and it can have consequences beyond just the court system. We saw that in Ferguson absolutely, and it's true in communities across the country. I want to end on this note. Our legal system has to be a reflection of our values. I mean, that's essentially how I think about the law. We look to courts to lift up the principles that we think should govern our lives. And so if we value the integrity of the judicial process, public safety, the fundamental principle of liberty, equal justice, and the presumption of innocence, then we should very carefully examine money bond practices the way they operate in many parts of the country, because as you've heard throughout the day, in many cases, they don't actually serve these principles. Thank you.